Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you, and what happened? Story 1. I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that is a serious accusation. I held up the guy's prior conviction for contract fraud and said I absolutely am. Your Honor, we won. Hands down, no further argument needed. Story 2. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console, in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest I've ever met in my life. 1T dismiss. We go to trial. During closing arguments, the DA says this case is a circumstantial evidence case. During my closing, I slapped the jury instruction on the projector that says if a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. At it, rip my inbox. Also, there are some amazing discussions below. That makes me really happy. I responded to as many questions as I had time for. DM me if you have a legal question about this case. Lots of you were interested, so the jury instruction is Calcrim 224 if you want to look it up. Story 3. Not a lawyer, but took my bill's landlord to small claims court. He's on C and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay. He did, and that is why she kicked him out. I am very organized, and presented the judge with a folder containing photos, receipts, short videos on DVD and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming that the apartment was trashed. There were holes in the walls and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my bill's apartment obviously still being lived in. His stuff was all still there, and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can see it. It is behind all of the posters." The judge frowned and looked at the video again, and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. Story 4. I had to go to court over a financial cock-up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor. So I went in alone. The judge didn't like this, and postponed it for another date so I could prove I had more counsel first. The other party's solicitor caught me outside the court and said I didn't tell you this, but and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone and got the entire thing thrown out. The other solicitor winked at me as he left, saved me about $9K. Nice chap. Story 5. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Edit. Spelling. Story 6. Oh my god, that is brilliant. I am not a lawyer, but I assess people for physical capacity after workplace and vehicle accidents. My favorite trick which this story reminds me of is with clearly dodgy people reporting shoulder injuries and only one shoulder is to get them to lift both arms as high as they can at the same time, because they are so focused on emphasizing how much they can move the injured arm they suddenly are hardly moving both arms, injured and non-injured. They get quite cranky when I say hold on, there isn't anything wrong with your other shoulder, why can't you move that one either? I am going to try this guy's method and see what I come up with. Story 7 Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VOA and the property is HUD subsidized. Also, MD Law offers DV protections too. Landlord as counsel during his opening talked about how my client was beaten and the police were called and an ambulance etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response, no your honor, I believe opposing counsel has said everything that needs to be said. Judge smiled and ruled in my client's favor. Landlord can evict DV victim. Story 8 My family did foster care for a few years, and we fell in love with the last girl we took in, now my younger sister. She was required to keep in regular touch with her emotionally and physically abusive birth mom, the intention being for them to eventually reunite. This woman was a horror every single time they interacted. She'd spend the duration painstakingly shredding my sister's self-confidence. My parents worked hard to establish a strong rapport and a supportive environment, and she blossomed under their care. She's one of the most resilient people I know. When the state tried to return her to her mom, she didn't want to go. So my parents sued. I think, don't really know all the legal details, for guardianship. This seemed like it would be an uphill battle. Here we were, a family of randos trying to steal a kid from her rightful mom. We were really afraid that she would have to go back, and that her shitty family would systematically undo all the hard work she'd done rebuilding her self-esteem. Fortunately, her dumbass mom decided to represent herself at the guardianship hearing. I wasn't in the room, but I heard the audio recording later on, and it is incredible how thoroughly this woman shot herself in the foot. Some highlights: she kept trying to testify while cross-examining people, e.g., would it surprise you to learn that blah blah blah. The judge called her out for this like 6 separate times and she just kept doing it. She would admit to various incidents of emotional abuse, but then try to argue that it was all justified because her daughter was being a bitch. She'd ask witnesses, for example, and wouldn't you be angry if your daughter did this? Yes or no? My personal favorite and the best example of her proving our case, it is absolutely not true that I hit my daughter with a wooden spoon. I only tried and missed. I'll prove it. I can show you the mark it left in the doorframe. Needless to say, we won guardianship. My sister never has to see that awful woman again unless she damn well pleases. Story 9 I worked as an intern for a lawyer. Construction law, in France, are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Story 10 Not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the Vic. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated, numerous times and under oath, that he cannot work. Whether he is doing it for free, for cash or for fun has no bearing on the fact that he is doing roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work." The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. Story 11. A friend of mine was involved in a similarly bullshit case. He had picked up his mother's car to take it for some service. Got stopped for rolling through a stop sign. Police officer spotted a handgun poking out from under the driver's seat. It was his mother's gun, legal and registered to her. My friend didn't know it was there. Cop arrested him for possession of the gun. Don't know the specific charge. After months of BS from the prosecutor, it was finally dropped. Story 12. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel, basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it is going to be a tough case, but not unwinnable. Then we get the response to our complaint where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client? The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks opposing counsel. I guess you were ineffective for both of you. Story 13. Yano. But the opposing party made it easy for us. We were tubing down a small river in rural Ohio. We had only been in the river for a quarter mile when we get stopped by rangers doing checks on who knows what, probably for people drinking. They stop us, and after 30 minutes, tell us that we have to leave the river and give us a ticket. When my dad asks why, they say it is because the boat that my 4-year-old brother is using is not licensed by the state and that it does not have the mandatory safety equipment on board, being life jackets, medkit, and fire extinguisher. I am on mobile so I can post a link, but the boat is something you get from a Toys R Us for your pool. Long story short, my dad fights the ticket and, per their request, brings the boat to the courtroom. He said he walked in with the boat folded and tucked up under his arm. The judge asked, "Is this the boat in question?" My dad said, "Yes, Your Honor. If you give me 5 minutes, I could blow it up for you." He also went on to say that if the safety equipment was in the boat that it would sink. He won right then. The court costs were as much as just paying the ticket, but it asked the little things. Story 14. Y'all sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour despite doing their payroll by the hour because they had a USP subcontract that supposedly told them to pay by the route. Defense calls the owner of the business to the stand and questions her about the contract, which is clearly incomplete. She explains that the company gets a new subcontract every 4 years, without fail. On cross, I flipped to the first page of the contract and read the date, which is in the spring of 2011. Q. Did I read that correctly? Yes, Q. And you get a new contract every 4 years. Yes, Q. So you got a new one around the same time in 2015. Yes, Q. And why you haven't produced that contract today? I haven't seen it in years, but it asks the same thing. Q. Where does this contract tell you to pay your drivers by the route? When she can't answer, I follow up with, and the 2015 contract that we don't have says the same thing. My client started working for them at the end of 2015. Their whole argument was based on a contract they couldn't find. We won. Story 15. I was an attorney for the estate of a husband defending against claims for money by the separate estate of a wife over proceeds from the sale of a business back in 1996. Both husband and wife died in 2010. Suit was filed early 2011, went to trial in 2014. Wife got around 10 of the business in 1996. Husband got the rest. He had built and operated it for 35 years prior to marriage and sold it 7 years into the marriage. The whole case hinged on whether the valuation of the business in 1996 was reasonable or not. We say you can value a business 15 years later with all the documents gone and all the main people in the business dead or missing. They say they have enough info to show the 1996 valuation should have been higher. Opposing counsels gets a big-time expert to testify that the business sold a 45M based on a valuation, but should have sold for 70M, and the husband hid 25M in real estate in the transaction. We get that testimony and then realize the 1,996 valuation of the business was done by the same expert. This is the absolutely most perfect catch-22 I have ever seen. So now we ask, okay, so was your valuation wrong in 1,996 or is it wrong now? Expert says his 1,996 valuation was right based on the information he had in 1,996, but his valuation now is more correct. Which then bears the question, what information do you have now that you didn't have in 1,996? Answer: I don't know. I don't have my file from 1,996. Nobody keeps documents that long, and despite this lack of records, his valuation is somehow more correct now. Judge basically said the expert was talking out of both sides of his ass and we won. Story 16. When I first started practicing, I handled a custody case where my client mom had a problem with dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied that he doesn't smoke tobacco, only weed in the house. Obviously this raised eyebrows as it is illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. He actually said this, and doesn't he recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. Story 17. My public defender wife, not a Redditor or ID getter to speak for herself, was trying a case where the defendant was accused of filling fraudulent prescriptions. Now keep in mind, PDs deal with a lot of shady characters who maintain their innocence with increasingly implausible stories as the evidence gets worse. So you can get a bit jaded after a while. But you don't have to believe your client's story to represent them vigorously. So the prosecution has grainy surveillance video of someone who looks like the defendant getting the prescription filled, and they'd used to fill it, which belongs to the defendant. Defendant maintains that someone stole his it and is using it because they look similar, but never reported the it is stolen. Wife is skeptical that the jury will go for that, but she is always willing to go to trial if that's what the client wants, so preps that defense and heads into trial. Prosecutor brings in the pharmacist who reported the prescription issue, goes through the usual routine of establishing who she is, where she works, was this the it used that day, etc. Finally, the prosecutor asks the pharmacist if the person who attempted to fill the prescription that day is in the courtroom. Nope. Story 18. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. Story 19. Yo, not my case, but I was in the courtroom watching a trial. Pro se defendant who was accused of fleshing a guard and masturbating till, well, you know, as a pro se defendant, he defended himself at trial without an attorney. Prosecutor was doing well proving the case. When the female deputy was on the stand, the defendant asked her one question: if you saw me do what you claim I did, then how big is my dick? The deputy responded by raising her hands and estimated about 15 inches. The guy grinned, turned to the jury, nodded, said yeah, that's right, and sat down. Obviously he was convicted. He was doing a 10-year prison sentence, so this conviction wasn't of much consequence, but I'll never forget it. Story 20. My dad is a lawyer. It has happened several times that the defendant submits or provides video evidence of assault or unlawful detainment, but assumes it will go unnoticed in 50 hours of footage. My dad watches everything. He got a multi-million-dollar settlement from a major casino after pointing out a moment that proved video doctoring. At it there was a car 1-2. He had a bunch of recordings and found a spot in the recording, submitted by the other side, where they are discussing what they need to show and how they will prove it. He played the recording in court as a surprise. They had nothing to say and he won after like 4 days of back and forth. I believe you have to get to a point where that evidence would come up. That is why he couldn't start there. My dad is a total badass. Story 21. Ooh, Ivy got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence, hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case, until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client. "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All as well that ends well. At it, obviously, but neither are most of these commenters, so I thought it was all right. Story 22. Plaintiff was claiming insurance money because he accidentally chopped off his fingers while cutting bamboo with a machete, and the insurance company, our client, refused to pay the insured amount. During the hearing, the plaintiff attorney began to demonstrate with a rolled-up sheet of paper how his client was cutting the bamboo when the accident happened. No matter how he tried, he could not reproduce the position of the fingers with the alleged cut of the machete. The only possible match would be if the plaintiff had deliberately extended his fingers over a plain surface and hacked his own fingers. Based on this disastrous performance, the judge determined an expert opinion and later dismissed the case due to deliberate self-mutilation. Story 23. Self-mutilation was really a thing back when I worked for this insurance company. I had a case in which the guy chopped off his forearm with an axe claiming he missed a tree branch. Another guy claimed he was repairing a lawn mower on a bench which fell off due to the vibrations, and he attempted to catch it midair, only to have all fingers sucked into the blade. The worst case I had was that of a farmer that was really in debt and committed suicide to get the insurance money for the family and save their property. His plan would have worked if he had not left a goodbye letter detailing precisely that he was killing himself to get the money. The case was dismissed and the insurance company did not pay a dime. Story 24. Parents were being sued by their landlord, and parents had a counter-suit against him. Parents were moving across country and found this house to rent. They did a walkthrough. Looks great. Landlord wants first, last, security and $1,500 because they had a dog and 2 cats. Fine, it was somewhere in the $8,000-$9,000 range, no big deal for them. They are set to move in on a Monday, so my mom flies in on Saturday to do one final look over, sign the contract and get the key. Perfect, they are now the tenants. Monday, they arrive and the house is fucking trashed. The landlord has moved a bunch of his stuff into the garage, shed, and one of the bedrooms. Their ass shit in the toilet, piss on the floor, garbage laying everywhere, used condoms. I can't really do this justice, but my mom took pictures and videos throughout the entire house. She calls the landlord and tells him that they are not moving in with the house in this condition. He tells her to clean the house and buy the first tank of oil for the house. It was empty. He tells her to do it, or he is keeping all the money for breach of contract. A lot of back and forth happens and tons of harassing texts and phone calls from him. Court day comes, and everyone is ready to submit their evidence in front of the judge. Parents have photos, texts, the contract, videos. Landlord only has the contract, but his contract is different than my parents'. He has included a section that states they permit him access to the house for his storage needs, and that tenant is responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. Judge tells the landlord he has a special level of stupid, and then the judge's final remarks were about how disrespectful the landlord was to show up in shorts, a Hawaiian shirt and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy and started a business under a different name. 2 years later, I went to his house, let out all but 19 psi from all his tires, and superglued the caps on the valve stems. Story 25. I do only civil litigation. You would think it would generally be a battle against equals, professionals v. Professionals, it is not. I face a fair amount of parties representing themselves pro se, often otherwise smart people who wouldn't think to do their own plumbing, or operate on their own appendix, but have no qualms about appearing in court on their own behalf. Surprisingly, they don't know what they were doing. So one of my favorites, from a deposition, we didn't pay company X's invoices because we heard they were going through bankruptcy. They weren't, and B, it wouldn't be a valid defense to non-payment if they had been. Story 26. You would think it would generally be a battle against equals, professionals v. professionals. So my dad owns a small vending machine business. He recently had a problem where a very small acquaintance asked him to buy some new equipment for them. He explained to them how it would be pretty expensive for him for not much return, but he'd do it if they agreed to use him exclusively for machines for 5 years. The owner happily agreed. About 3 months later they got some new company in and made him remove the machines. He decides to go to small claims about it. He didn't have a written contract with them and figured the owner would probably just lie about their verbal agreement, but he figured it was worth a shot. Several other people had been in the room, including the manager, when they agreed, so he hoped they'd be hesitant to lie to a judge. The boss shows up with his manager, who apparently used to be a paralegal, so she thinks she is hot shit. They had to go to some resolution thing where they try to resolve it, and the manager tells my dad how he had a bogus claim, there was no contract, they were gonna sue him for wasting their time, etc., etc. Then go before the judge, and she proceeds to tell the judge how they only had a verbal agreement and nothing was in writing, so it wasn't binding. When the judge informed her that verbal agreements were in fact binding, she decided to argue with him. My dad just sat back and smiled while they dug their own grave. Story 27. Not an attorney, but I did an internship at the city's attorney's office one summer, leading to not wanting to be an attorney. Man was suing the city for evicting him from a public housing development. Claims he doesn't speak English and forced the city to hire an interpreter for the hearing. City says he was evicted because he was raising chickens in the apartment. His attorney insists that is absurd, no one would do that. Pushes for proof the chickens were his client's. Judge wasn't convinced about the proof. Everything looks like it is going well for the guy until it comes up that the chickens were given to a farm for slaughter. Guy jumps up and starts yelling, "Give me my chickens back." In English, judge starts laughing, attorneys start laughing, case is dismissed. Story 28. Not a lawyer, but was taken to court once. A guy had taken my family to court, basically he had been dating my mother, and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat, he even billed for things he did, like house repairs. Some of the repairs were terrible, and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, while I was with them I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them. Judge, you bought a child a birthday cake with the idea it would be paid back. Did you ever say that these things were loans and not gifts? Him, well no, but I shouldn't need to. That is the normal way people think, judge. Well, that is not the way I think. Case dismissed. Story 29. I did not prosecute this case, but I saw it. The state was prosecuting an individual for reckless conduct with a deadly weapon and criminal threatening with a deadly weapon. It was a bench trial because the defendant was a foreigner and, I guess, the defendant was concerned that a jury would be biased against him. Essentially, the state alleged that the defendant waved a gun at 2 employees of a Dairy Queen and then discharged the gun in the air. The defendant was the manager of the Dairy Queen. So at the start of the case, the state requested a continuance because it could not produce the 2 employees. They had been subpoenaed, but didn't show. The judge denied the continuance. So the state decided to go forward. It put on its case, but wasn't able to introduce any testimony that the defendant brandished the gun at the employees or that he had discharged it near them. There were admissions that he had had a gun that night which he had shown to other people and testimony that the gun had been discharged. State rests. Defense does not move to dismiss and calls the defendant to the stand. I was watching in the gallery with some public defenders because trials were uncommon in that county. We immediately began whispering to each other about how he didn't do the motion to dismiss at halftime. The defendant testifies about how he wanted to scare the two employees as a joke. Then on cross, he testifies how he brandished the gun and what angle he was holding it when he fired. Defense rests. The judge had the longest delivery of verdict that I have ever heard. He said something to the effect of, "It is rare that you find a defendant that convicts himself by his own testimony. But that is what happened here. Without the testimony regarding the gun and the discharge, there would be insufficient evidence to convict." He goes on and on. While the judge was delivering the verdict, the defendant was standing, obviously. He faints and slams his head on the defendant's table. He ultimately was taken out of the courtroom on a stretcher and transported to a local hospital. There was blood all over the floor. The defense attorney, who was in his 60s, looked like he needed medical attention too. This would have been instant ineffective assistance of counsel, but he was immediately deported, which is the main reason he went to trial, because he was also a convicted felon, though not charged with felon in possession in this case. Andins was only waiting for the conviction to deport him, so he was sent back to his home country. This was the most messed up thing I have seen in court, and I have seen some wild shit. I felt bad for the attorney, but ultimately contacted lawyer as assistance about him because I saw him do other things that were almost as bad. As a prosecutor, I was worried about his clients who were paying him for the most part. The court was no longer appointing cases to him, and his ability to effectively represent them. Story 30. Not opposing counsel, but the plaintiff himself. I was trying a case in DeKalb County, Georgia, against a guy who claimed he had slipped and fallen in a Kroger store late at night while they were waxing the floors. He claimed the only signage anywhere near where he fell was a single yellow caution sign more than 85 feet away. We had a surveillance video and it indeed showed him passing by the sign as he entered the aisle. However, arguably, the sign didn't really indicate what was going on, since it wasn't apparent the aisle was being waxed and it was quite a distance from where he fell. On the stand, at the end of the first day of trial, I was cross-examining him about the signage and he made a comment in which he referred to passing the signs plural. It is very unusual to learn a new fact at trial after typically 2 years or so of depositions and discovery. I stopped where I had been going with my questions and asked him about the signs, and he admitted he had taken pictures of them and had them at his house. Well, this is a clear discovery violation since he is required to turn over all pictures, not just some, and we had clearly asked for them. However, when I went after the guy for concealing evidence, the judge chewed my rear end for getting into a discovery dispute in front of the jury. I still think she was wrong, and I got him to agree that he would produce the images the next day. We adjourned day 1 of trial. The next morning he showed up with the pictures, and it turned out he had walked directly between 2 caution signs set up on either side of the aisle like the pillars of Hercules. There was no ambiguity whatsoever about his notice after that, and the jury gave him $0. Story 31. Opposing counsel introduced a highly relevant and bloody crucial piece of evidence during the cross-examination itself. We were really pissed, and we had every right to argue that this was deliberate suppression of relevant documents during discovery, but rather than object to its admissibility, we asked for our lunch break to commence earlier so we could take instructions from our client as to how to proceed, which turned out to be a darn excellent course of action. The document prima facie looked supportive of the defendant's case, but it actually in substance was pretty damning for them. We basically came back from the lunch break to rub the defendant's witness face in it, and the witness was so shaken he broke, for lack of a better word to describe how he couldn't carry on his bullshit, and completely admitted to his negligence on the stand. He admitted as well that he copied the expert's opinion, instead of giving his own independent evidence. It was a beautiful trial. Story 32. I am not a lawyer, but a couple of years ago my family was sued by our neighbors for having a fountain in our front yard because it supposedly made too much noise, causing our neighbors to lose sleep. So, my dad, being a nice guy, said okay, I'll try to fix it. We put up walls around the filtration unit and redid the pipes to dampen as much of the water splashing sounds as much as we could. After finishing all of this, my dad even got a noise technician, not sure what they called, to come around the house with a decibel reader to verify that the noise was virtually gone. The tech walked around a couple of times and told us that the highest reading was 28 dB, so that we were good to go. So a couple of weeks go by no problem, but then we get served with a lawsuit again, over the same issue. So my dad is starting to get aggravated over this, and this time decides to get our own lawyer to dispute this. Well, court day comes and my dad and his lawyer have all the sound readouts, pictures of the stuff we did, etc. Well, the neighbors brought their evidence as well. Their strongest piece of evidence was a recording from inside their house that supposedly showed how loud the filtration unit was. But you couldn't really hear anything except our neighbor lady going, "Do you hear it? Ooh, right there. Oh, it's so loud." So when that evidence didn't bear the fruit that they wanted, they decided to show their next piece when ended their case. The next piece of evidence they tried to submit were pictures of our filtration unit, walls, and the various other things we did to dampen the sound. Well, in order to take those pictures, they would have needed to be on our property inside the walls we built. So our lawyer sees this and begins to ask them how they got those pictures, etc. They admit to the court that they trespassed to take those, and thus begins their downfall. Our lawyer showed the judge the decibel report and all that good stuff, leading to our neighbors admitting that the noise actually never bothered them, but it was the sight of our ugly filtration unit. The case was thrown out, and our lawyer then told us if we wanted to countersue we can, so we did. We got them on trespassing and harassment that they provided the evidence for. As it turns out, they were also upset at the fact that the HOA made everyone move boats and trash cans to the backyard, so our neighbors were upset that we got to keep the filtration unit in the front. Like really, TL Drive neighbor said koi fountain made too much noise, took us to court, brought evidence that incriminated him in another crime. Case thrown out, we countersue and win. The fish are happy.